but we could also search for the DUI.
In DUI investigations, actually strike that. I want to be clear, was marijuana what you suspected the defendant to be under the influence of?
No.
Can you tell the jury what you suspected him to be under the influence of?
Alcohol.
Was alcohol your primary concern throughout your investigation?
Yes.
Now I want to transition also to the breath test that you asked from the defendant. Opposing counsel asked you a bit about how the defendant was leaning towards you. Can you describe to the jury what it was like when he was leaning towards you as you read the implied consent form?
Objection, relevance.
Overruled.
Can you tell the jury what it was like as he leaned towards you when you read the implied consent form?
Sure. So I was just trying to read the implied consent form. Like I said, it was one of those procedural things for a DUI, and he was yelling at me the whole time. And then when he was leaning towards me, I didn't know what his intentions were. So that's why I shut the door, and then I continued reading implied consent through the open window. I thought he might, if I had kept the door open, I thought he might try to exit the vehicle or try to, I guess,
Objection calls for speculation.
Sustained.
Officer, can you just give us a visual estimate with your hands about how far away he got to you, or how close he was to you when he leaned towards you?
I would say probably that close.
No further questions.
Does this witness need to be retained?
Yes, Your Honor.
All right, you can step down, but please do not leave the courthouse.
Thank you. I still have the paperwork that.
You can retrieve it. Yes. State, you may call your next witness.
The state calls Sergeant Smith to the stand. And if I could just have a moment to clear the ball.
You could stop right there and let the clerk swear you in, please. All right, you may have a seat. State, you may inquire.
Thank you, Your Honor. Could you please introduce yourself to the members of our jury?
Yes, my name is Brian Smith. I'm a sergeant with the City of Tallahassee Police Department.
And for the record purposes, can you spell your last name?
Yes, it's S-M-I-T-H.
Sergeant Smith, I want to talk about your experience as an officer for starters.
Yes, ma'am.
Could you tell us, I know you said you work for the Tallahassee Police Department. When did you start working for them?
In December of 2008.
Okay. So for a total of how many years at this point?
It's 15.
So during the 15 years at Tallahassee Police Department, did you receive any training related to DUI investigations?
I did not specifically, no ma'am.
Okay. Have you ever responded to DUI investigations?
Yes ma'am.
Are you usually backup, or can you give us a little insight into what your involvement usually is?
Typically it's as a backup officer, so it would just be for, while the officer is conducting their investigation, I would just be there for safety purposes. Or to assist with traffic control, just depending on the situation.
Okay. So I want to transition over to this case.
Yes ma'am.
Do you recall if you were on duty the early hours of May 7th, 2023?
Yes, I was.
Were you called to a scene of a traffic stop around 2 a.m.?
Yes ma'am, I was.
Can you tell us what your understanding of your involvement was that morning?
Initially, they just asked for me to respond. When I got there, I was informed that Mr. Riley had been combative, and they just needed assistance getting him from Officer Oliver's vehicle to Officer Mule's vehicle.
Do you recall what time you arrived at?
It was right around 2:25, 2:26-ish in the morning.
So when you arrived at the scene, did you end up speaking with the defendant at all?
Yes, ma'am, I did.
Did you have your body-worn camera footage on?
Yes, ma'am, I did.
If I showed you a copy of that, would you recognize it?
Yes, ma'am.
Permission to approach?
Yes.
Let the record reflect from showing opposing counsel was their pre-market states exhibit G. And I am now approaching the witness of this. Sergeant, I've just handed you what's pre-marked as States Exhibit G. Can you tell us what that is?
It's a CD
And-
with my signature on it.
What's on this CD, to your knowledge?
It's actually my body-worn camera from the night of the incident.
Did you have an opportunity to review that before today?
Yes, ma'am, I did.
Were you able to confirm if this was a fair and accurate copy of your body camera?
Yes, ma'am, it is.
Has it been changed or altered in any way since you last seen it?
No, ma'am.
The state moves into evidence what's been pre-marked as States Exhibit G as States Exhibit 6.
Any objection?
We would object and ask to approach on one brief testimony.
Sorry, ladies and gentlemen, we need to take another break. This is going to be a very short one. I just need to listen to something and rule on it outside of your presence. If you can please leave. What's the defensive position?
I was going off of the standard instructions that give 2A, 2B, or both as applicable, but if I could have a moment to review that case.
Okay.
And sorry, what was that final number? 739 Southern 2nd? 1200. 1200, thank you.
You may be seated. The bench may proceed.
At this time, the fence rest.
Okay, thank you. So members of the jury, I want to thank you for your attention during this trial. Please pay attention to the instructions I'm about to give you. Calvin Riley, the defendant in this case, has been accused of the crime of driving under the influence. To prove the crime of driving under the influence, the state must prove the following two elements beyond a reasonable doubt. 1. Calvin Riley drove or was in actual physical control of a vehicle. 2. While driving or in actual physical control of the vehicle, Calvin Riley was under the influence of alcoholic beverages to the extent that his normal faculties were impaired. Vehicle is every device in, upon, or by which any person or property is or may be transported or drawn upon a highway. Normal faculties include, but are not limited to, the ability to see, hear, walk, talk, judge distances, drive an automobile, make judgments, act in emergencies, and in general, to normally perform the many mental and physical acts of our daily lives. Impaired means diminished in some material respect. Actual physical control of a vehicle means the defendant must be physically in or on the vehicle and have the capability to operate the vehicle, regardless of whether he is actually operating the vehicle at the time. Alcoholic beverages are considered to be substances of any kind and description which contain alcohol. Count 2 has been removed from your consideration. It is no longer of concern to you. Plea of not guilty, reasonable doubt, and burden of proof. The defendant has entered a plea of not guilty. This means you must presume or believe that the defendant is innocent. The presumption stays with the defendant as to each material allegation in the information through each stage of the trial unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction that is not one which is stable but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witness acted as well as what they said. Some things you should consider are: did the witness seem to have an opportunity to see and know the things about which the witness testified? Did the witness seem to have an accurate memory? Was the witness honest and straightforward in answering the attorney's questions? Did the witness have some interest in how the case should be decided? Does the witness's testimony agree with the other testimony and other evidence in the case? Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? I can't remember if I skipped one. Did I skip one? No. Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. The Constitution, excuse me. The Constitution requires the state to prove its accusations against the defendant. It is not necessary for the defendant to disprove anything, nor is the defendant required to prove his innocence. It is up to the state to prove the defendant's guilt by evidence. The defendant exercised a fundamental right by choosing not to be a witness in this case. You must not view this as an admission of guilt or be influenced in any way by his decision. No juror should ever be concerned that a defendant did or did not take the witness stand to give testimony in the case. There are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. You must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. This case must be decided only upon the evidence that you have heard from the testimony of the witnesses, have seen in the form of the exhibits and evidence, and these instructions. This case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. Remember that the lawyers are not on trial. Your feelings about them should not influence your decision in this case. Your duty is to determine if the defendant has been proven guilty or not in accord with the law. It is the judge's job to determine a proper sentence if the defendant is found guilty. Whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. Your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I prefer one verdict over another. You may find the defendant guilty as charged in the information or not guilty. If you return a verdict of guilty, it should be for the highest offense which has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course your verdict must be not guilty. The verdict form must be unanimous, that is, all of you must agree to the same verdict. Only one verdict may be returned as to each crime charged. The verdict form must be in writing, and for your convenience, the necessary verdict form has been prepared for you. It is as follows. The verdict form has the style of the case on top. It says verdict. We, the jury, find as follows as to count one of the information, driving under the influence. Check only one. A, the defendant, Calvin Riley, is guilty. B, the defendant, Calvin Riley, is not guilty. It needs to be signed and dated by the foreperson, and please bring it back with you when you return to the courtroom. The attorneys will now present their final arguments. Please remember that what the attorneys say is not evidence or your instruction on the law. However, do listen closely to their arguments. They are intended to aid you in understanding the case. Each side will have equal time, but the state is entitled to divide this time between an opening argument and a rebuttal argument after the defendant has spoken. State, do you wish to give a closing argument?
Yes, Your Honor.
You may proceed.
I just have a moment to prepare the law. Your Honor, if I may just turn this on briefly, make sure it's. may proceed.
Mr. Mayor?
May it please the court, defense, and members of the jury. It was 2 a.m. and the defendant was driving down South Monroe Street with no headlights whatsoever. We learned in today's trial that it wasn't just as simple as him forgetting the lights. He didn't notice that his headlights were off for at least 5.5 miles. He didn't realize. And when he was finally stopped by law enforcement, his words tell us all that we needed to know from the start. Of course I've been at the club, had a couple of drinks. I've been at that club. I've been at Pockets Pool and Bar. His words
She do look like one of them cops that do be outside like that, though. I ain't gonna lie to y'all.
are all we need.
Nah, cop. I think this is a DA agent actually, or one of the attorneys or something like that. But she definitely like she be outside.
Statement of law.
Now I want to pause for a
Your
moment.
Honor, the statement of law.
Sustained.
I want to pause for a moment and thank you.
Just
Because-
hold on a second, Ms. Hershey. The state has just misstated the law for what is needed for driving under the influence. Please use the jury instructions that I presented to you as your instructions on the law. You may proceed.
I wanted to pause for a moment and just say thank you to everyone for being here. I know we spent Tuesday all together going through jury selection and deciding who would be a best fit for our jury. And throughout this process, you've all been great. We went through Friday, and of course there were some delays, and of course you also had to take time out of your day today, which was not expected. And to say the least, we couldn't have gotten through this process without you. So I commend you all for that, and I'm beyond grateful for that. So what I wanted to talk about is what the law is in this case and what we have to look to see whether or not the state has met its burden. As the judge just instructed us, the defendant in this case, he's charged with driving under the influence. Now, driving under the influence has two individual elements that the state had to prove to you here today. First, the judge told us that the first element that the state needed to prove is that the defendant drove or he was in actual physical control of a vehicle. Now, members of the jury, I don't think this is something that's in dispute in this case. We've seen the body-worn camera. We've seen testimony from two officers who told us here today that when they first encountered the defendant, he was driving his vehicle down South Monroe Street. The body-worn camera footage that we saw on the televisions that are in front of you showed the defendant inside his white Mercedes when law enforcement approached him. They showed him in the driver's side seat behind the steering wheel, and he was the only person in that vehicle. So when we look at the evidence and the facts in this case, we know that the state has in fact established the first element, that he was driving a motor vehicle. So that brings us to the second element. And this is the second element that you really are here today to decide. See, as the judge just told us, while driving or the state must prove that while driving or in actual physical control of the vehicle, Kelvin Riley, the defendant, was under the influence of alcoholic beverages to the extent that his normal faculties were impaired. Now that element is a bit lengthy, so I want to break it down into two separate parts, starting with under the influence of alcoholic beverages. We learned throughout today's trial that the defendant was undoubtedly under the influence of alcohol. There's multiple things that we learned that through. We learned that through his own admissions. When Officer Muth approached the vehicle,
Objection, please statement passed.
Let's go sidebar. Objection is sustained. Just restate your statement.
So, as I was previously stating, the first element, or the first part of this second element that we have to prove is that the defendant was under the influence of alcoholic beverages. Now, when we look to the facts and the evidence in this case, we know that there's several signs or several statements from the defendant that point us to the conclusion that he was under the influence that night. For starters, he admitted to Officer Muth at the scene that he had had a couple of drinks that night. He told Officer Muth that he was at a bar that night, that he was out at a club. How do we know he was out at the club? Well, we saw the wristband on his wrist that corroborated that statement. We know he was out drinking that night. We know that he was out there, and he left around the time that bars close. It was 2 in the morning. So when we look at that element, we would assert that it's been proven. And if that's not enough, we can also look to other things. We can also consider whether or not his normal faculties were impaired. And that's the second part of element 2. As the judge just instructed us, normal faculties include multiple things. It includes our ability to see. So when we're talking about the defendant's ability to see that night, there's several things that officers noted that were concerning. So let's talk through those. Starting with Officer Oliver. Officer Oliver told us here today that when she first saw the defendant, he was driving down the road in his white Mercedes. And as he was driving down the road, he didn't have his headlights on. Like I mentioned earlier, he was driving nearly 5.5 miles with no headlights, and he couldn't see that? It's dark outside, it's 2 a.m., and you can't tell that you're driving down the road in the dark? What does common sense and reason tell us? See, when we look at the jury instructions, we see that when somebody's normal faculties are impaired, it means that impairment means that those normal faculties are diminished in some material respect. And when you can't even tell that your headlights are off, I think it's safe to say that your ability to see has been diminished. And if that's not enough, there's another part that we should talk about. Because when Officer Oliver tried to tell the defendant about his headlights being off, he didn't believe her. He asked her, "Are you sure about that?" I believe those were his words. "Are you sure about that?" It took Officer Oliver debating with the defendant about having his headlights off that she finally had to reach inside his vehicle and show him the turning knob to turn them on. He still didn't believe her until she finally clicked the knob to the right and showed him that they were off. And it wasn't until the lights on his headlights finally illuminated that he finally widened his eyes and then turned to Officer Oliver and still questioned her judgment and her ability to see that his headlights were, in fact, off. It's not reasonable. And the reason that we know that his sight was impaired was because of his admission to drinking alcohol that night. So that brings us to another normal faculty that I wanted to discuss with you. We listened to the defendant talk about, or one of the additional normal faculties that we should consider during deliberations is the defendant's ability to talk that night. Now, don't get me wrong here. The video was sometimes a little hard to hear, but then other times we know he was clear. He was shouting, he was yelling. Those times it was crystal clear. And when we watched those videos here in court today, it was clear that there were times that he was slurring his words. He was not making sense. For example, when Officer Oliver stopped him in his vehicle, he said, "Why you slow me down?" Is that a statement that makes sense? No. But that was what was running through his head at that time. Why you slow me down? So we have to look at his speech in those moments and whether or not we think based on his speech that it was diminished in some material respect. So let's talk about another one now. The defendant's ability to judge distances. Members of the jury, this is a big one. And I encourage you to remember the demonstrative that I showed during the testimony of Officer Muth. So I want to turn that on for you guys. This is a map of the defendant's route that night, based on his own admissions. Like I originally stated, when he was first stopped by Officer Oliver, first he says, "Oh, I'm just going home, I'm going to West Brevard Street." Well, that didn't make sense, because as Officer Oliver told us on the stand on Friday, he was heading the opposite direction. So, are you really going home if you're going completely the opposite direction? I think not. So now let's look at the other perspective. Because after Officer Oliver gets to the scene, Officer Muth, as she told us, went and did her own independent investigation. She told us here today that she went up to the defendant and asked him, "Where are you going? Where were you planning on going?" He said he was going home. And when she asked, "Where are you coming from?" she said, he said, "I was coming from Pockets." And as we learned in today's trial, Pockets is a local bar here in Tallahassee located on the north side. So when you look at that map that we showed you during today's trial, you can see that the route just doesn't make sense, and his ability to judge distances was materially diminished. Right here on this map, we see Pockets Pool and Pub. If we're taking the defendant's own word for what happened that night, that means he would have traveled south on South Monroe Street all the way down to the intersection of South Monroe Street and Laura Lee Avenue. We see how far he went, passing by his own residence, passing by the home he said he was heading to.
Objection, Your Honor, facts not evidence may be approved.
Yes. Overruled.
Now, I'm sorry for the pause in there, but I wanted to get back to what I was saying. Members of the jury, as we saw in today's trial, he would have started at Pockets Pool and Pub, all the way up in the north side here in Tallahassee. If we take the defendant's own word for what happened that night, he would have traveled well past his home address, well past that West Brevard Street address that he kept telling officers about that night, all the way down until he got to Laura Lee and South Monroe's intersection. That's where law enforcement finally stopped him because he didn't have his headlights on. And that's finally where they stopped him, and who knows how much further he would have gone before law enforcement stopped him that night. It's not clear, but it clearly wasn't in the direction of his home, because if he was heading home, he would have to turn all the way around and go the exact same way north back to his address. So, members of the jury, when we're talking about the defendant's ability to judge distances, we know that his ability to do so was diminished in some material respect. Absolutely. The jury instructions also say that normal faculties include your ability to drive an automobile. That's another thing that we heard about in today's trial. Not only the lack of headlights, but also Officer Oliver told us about his driving pattern when she went to stop him. He was speeding down South Monroe Street. At least 10 miles. Who knows, maybe potentially more. We don't know because Officer Oliver didn't have a speed gun to tell us exactly how far. But based on her training and experience, she was able to assess that he was speeding that night. Now, he wasn't just speeding. He was speeding past 2 police cars, with one of them that at least had their headlights on. Does that make sense? To drive over the speed limit as he's passing a police car with its headlights, its emergency lights activated. You can't miss that. But he was speeding. We also learned that in addition to the speeding, he was swerving. Officer Oliver got on the stand and told us about how she was concerned based on how he was operating his motor vehicle. See, when he was in the left-hand turn lane, there was a when he was in the left-hand lane, there was a vehicle coming up on the side of him in the right. Officer Oliver told us here on Friday that while he was passing this vehicle on the right, he started swerving. And although he didn't collide, he could have and almost hit that vehicle. His ability, members of the jury, to drive an automobile safely was diminished. The next one talks about the ability to make judgments. And this is another thing that we've talked about in 2 different respects. First, when law enforcement asked the defendant to complete a breath test. Now, we learned about the consequences of refusal of a breath test here in Florida. Officer Muth read to us here today the exact same.
We're back on the record. Davey Riley, defendant is present at counsel table and jury is present in the courtroom. Has the jury reached a verdict?
Yes.
All right, please pass the verdict form to the bailiff. Madam Clerk, please publish the verdict. Mr. Riley, please stand.
In the matter of the state of Florida versus Calvin Riley, case number 2023-CT-854, we, the jury, finds as follows as to count 1 of the information, driving under the influence. The defendant, Calvin Riley, is guilty. So say we all this 8th day of April 2024.
You may be seated. Does either side wish to have the jury polled, state,
No, Your Honor.
defense?
Yes, Your Honor.
All right, Madam Clerk, can you please poll the jurors?
Juror number 1, is this your verdict? Yes. Juror number 2, is this your verdict? Yes. Juror number 3, is this your verdict? Yes. Juror number 4, is this your verdict? Yes. Juror number 5, is this your verdict? Yes. Juror number 6, is this your verdict? Yes.
So, ladies and gentlemen, I wish to thank you for your time and consideration of this case. I also wish to advise you on some very special privileges enjoyed by jurors. No juror can ever be required to talk about the discussions that occurred in the jury room, except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. We have recognized for hundreds of years that a jury's deliberations, discussions, and votes should remain their private affair as long as they wish it. Therefore, the law gives you a unique privilege not to speak about the jury's work. Although you are at liberty to speak with anyone about your deliberations, you are also at liberty to refuse to speak to anyone. A request to discuss either your verdict or your deliberations may come from those who are simply curious, from those who might seek to find fault with you, from the media, from the attorneys, or elsewhere. It will be up to you to decide whether to preserve your privacy as a juror. Thank you again for your time and attention, especially for coming back today. We appreciate your work on this jury. You are excused. All right, you may be seated. All right, Mr. Riley, you've been found guilty by the jury. I now pronounce you guilty of one count of driving under the influence. Is the state ready to proceed with sentencing?
Can I just have a moment, Your Honor?
Yes, you may.
Your Honor, I'm ready to proceed.
Okay.
The state would be asking for 12 months probation with, as a special condition, 10 days jail, in addition to the other required mandatory minimums under the DUI statute.
So that's the DUI. Are there any prior DUIs?
No, Your Honor.
Okay, so DUI level 1, the 50 hours of community service, 10-day vehicle impound, the 6-month DL suspension. I don't have a standard plea form in front of me. Do you remember what the other standard DUI firsts are?